The new Department of Labor Fiduciary Rule is perhaps the most significant regulatory development impacting service providers in the retirement markets since the enactment of ERISA in 1974. I'm Olga Greenberg.
And I'm Wilson Barmeyer. Sutherland's DOL Fiduciary team is advising broker-dealers, investment advisors, and other service providers on the impact of the new rule and the potential litigation risk. Olga, how does the new rule impact the landscape?
Well, the impact is really twofold. First of all, the new rule greatly expands the definition of ERISA fiduciary and who will be considered an ERISA fiduciary going forward. And second, the new rule creates a private right of action under what's known as the BIC exemption, the best interest contract exemption, for IRA owners that did not exist under existing law. Under the current regime, broker-dealers are not deemed fiduciaries absent very limited circumstances. Investment advisors are considered fiduciaries under the Investment Advisor Act of 1940, and of course will continue to have that status going forward. But things have very much changed.
That's right, Olga. Under the new rule, both broker-dealers and investment advisors will be deemed fiduciaries, both for recommendations regarding selection of an account, most typically in the IRA rollover context, and also advice regarding investments within that IRA account. The centerpiece of the new rule is the BIC contract, the best interest contract. For broker-dealers and investment advisors to continue receiving compensation that they've traditionally received for their services, they will in many instances be required to enter into a written BIC contract with the retirement investor under which they take on fiduciary status and commit to providing advice that's in the best interests of the retirement investor and without regard to their own compensation.
The BIC contract places many requirements, but of course it must address the compensation structure, conflicts of interest, and may not contain a class action waiver, which opens the door to a new area of litigation in this space that will impact the IRA markets. Wilson, can you talk briefly about the types of claims we will likely see in this space?
Thanks, Olga. We expect to see a host of litigation issues arise under the BIC contract, but initially we would expect the plaintiffs' bar to borrow from some of the theories that have been asserted in ERISA class actions to date. I'll mention three possible claims: scrutiny of compensation, conflict of interest, and imprudent investment advice. On scrutiny of compensation, we expect to see a real focus on the compensation, both at the total level, but also particularly any differential comp. These claims might be similar to the excessive fee litigation we've seen against ERISA plans. Second, on conflict of interest, a potential claim could involve conflict of interest related to compensation, a proprietary product, or some other alleged conflict of interest. And lastly, there could be allegations of imprudent investment advice. And to defend against those types of claims, a broker-dealer or investment advisor will want to be able to show that it followed a prudent process in making a recommendation to the retirement investor.
For more information on these issues, please feel free to contact one of us or visit Sutherland's dedicated page, dolfiduciaryrule.com, for more information on the new rule, its practical implication, and litigation issues that we've discussed today.
And for more bottom line videos, please visit Sutherland.com. I'm Wilson Barmeyer.
And I'm Olga Greenberg. Thanks for joining us.